May I just check, please? Is the lawyer for Ms. Macniven present?
She's just gone out, in fact.
Well, let us wait until it's appropriate to wait.
Ah, there we are.
Don't worry. Right, Mr. Hill, we're ready.
Thank you, sir. Mr. Macniven, I'd like to begin with questions about decision-making within the Scottish Home and Health Department. Could we have on screen, please, PRSE 302521, which is Dr. MacDonald's response to Dr. Cash that we looked at earlier in respect of the complaint over Dr. Forrester. It's actually a different point that I'd like to pick out from that in the third paragraph, where Dr. MacDonald is referring to Dr. Cash's reference to the delay, as Dr. Cash saw it in AIDS validation studies. Dr. MacDonald writes, and I quote, "These matters were decided at Deputy Chief Medical Officer, and ultimately ministerial level." The question that I'm asked to put to you arising from that is that decisions about anti-HIV testing went to ministers in 1985. Why were decisions about surrogate testing not put to ministers in 1986 and in 1987?
Okay, I wasn't involved at the stage that Ian MacDonald is referring to in this letter, so I can't make the comparison that's necessary to answer your question properly. I would merely refer back to the points that we were making, that I was making earlier, both in relation to contact with ministers generally and contact with ministers specifically on surrogate testing, that it is very difficult, a difficult matter of judgment when to put matters to ministers. And I think I explained quite fully why we had not done so in the case of surrogate testing. But it's difficult for me. I can't make the comparison that you seek.
Can I just perhaps pose it this way as a structural matter rather than specific? The decision in 1985 was to introduce testing. And so obviously a minister has to be involved when the expense is going to be laid out. A minister doesn't have to be involved if the decision is to maintain the status quo. Does that mean that it is less likely that a decision to maintain the status quo will end up being put to a minister?
Yes, that's a fair point. It's necessary, I would suggest, not only for expenditure authorization purposes, but more importantly for a change in procedure for ministers to be consulted. So if, for example, we had decided that surrogate testing was a very good thing, we would have undoubtedly put it to ministers to check that out, as was, I deduce, the case in the example that Ian MacDonald's referring to. In other words, it becomes more clear-cut, that difficult decision of when to involve, whether to involve ministers, it becomes more clear-cut if there is a specific positive decision for change recommended. But there was not a difficulty in putting things to ministers. We were not at all deterred in our view that surrogate testing should not be introduced on present level of knowledge. That was a decision that we revisited. We were not deterred from introducing it by the feeling that it would be necessary to involve the minister, and that was a difficult thing. It wasn't a difficult thing at all. The procedures for involving ministers were straightforward. The difficulty was in deciding when a matter was ripe for ministerial decision.
I've been asked to pick up on something that you said earlier about difficult cases going to the minister. Are you able to give any examples of what those difficult cases were, or any criteria, not set criteria, but general criteria that might lead to a difficult case going to the minister?
Yes, I understand the question, and as you hint, there were no set criteria. The sort of thing that we would have put to ministers, and I'm sure the same kind of criteria are around today, there's nothing peculiar about them, is whether it was a matter of public note, whether the minister was likely to be criticised, or the government be likely criticised in the press or in the public. That would make it, or in Parliament rather, that would make it more likely that we would put a decision to ministers. If there was some kind of ethical question, we might be more likely to put it to ministers. It's that kind of thing which is in question in that difficult area of when do you put things to ministers. Might I observe that it would be interesting to ask Michael Forsyth that kind of question tomorrow? You may already expect to do so, because it would be illuminating to get the minister's eye view on that difficult question. Did the civil service generally get it right in what it put to ministers? But my experience was that generally we did get it right. As I observe in my written evidence, I can remember a handful of cases where I was criticised for not putting an issue to ministers. There wasn't a large seam of criticism about that difficult judgment call.
Where would the criticism come from? Because obviously a minister who hasn't seen something won't know that he hasn't seen it.
But might discover afterwards. It would be mostly the minister discovering in retrospect that an important decision had not been put to him or her.
The handful of examples that you give, are they all taken from this period, 1986 to 1989?
No.
Or are you talking across your career? Sorry, across your career then?
Yes.
Yes. And you said earlier in your evidence that almost without exception, you got the judgment call of when to put something to a minister right.
In the view of the minister, we got it right. Whether it was objectively right or not is a difficult question to answer.
So you're basing that on the response that you got from ministers across your career?
Correct.
About what, turning to the group of 7 people that you mentioned who were the equivalent of the policy unit, not in a formal sense, but the group that you raised when I brought that issue up with you. I've been asked to ask you whether, in essence, policy about the blood transfusion service in Scotland was run by that group of 7.
Yes, as I made clear at the time, it wasn't a formal group. If we wanted to take a view on something, that's the sort of dramatis personae that we would assemble.
Do you think that it is a fair characterisation that the BTS in Scotland was run by that group of 7?
No, the BTS in Scotland was run by John Cash and the regional transfusion directors and Bob Perry. The question was more about the formulation of policy.
The group of 7 that you mentioned didn't include any haemophilia centre directors, for example.
Correct.
Sorry, please go on. I think you were about to say something.
Correct. But the haemophilia directors were very close to the regional transfusion directors, and thus to John Cash, and B, at the haemophilia directors met periodically, and John Forrester, and no doubt Bert Bell before him, was invariably present when they met. So their views were, to some extent, represented by the medical staff of the department. The haemophilia directors, though, were in a different organisational position. They were part of the 15 regional local health boards. The policy group that I was talking about was purely within SHHD and the BTS, because you were asking me what the equivalent of an English body was. Now, the group that I've cracked up was not a formal body; it was an ad hoc assembly. But I deduced that English. I deduced, perhaps wrongly from your question, that group was essentially the Department of Health one.
Were you concerned, either at the time or retrospectively, that there was an imbalance in the strength of voice of the manufacturers of blood and blood products in Scotland when compared to those who were using them, the haemophilia centres?
I certainly wasn't aware of that at the time, and I have no retrospective view of authority.
Turning to the CSA oversaw the Central Legal Office as well as other services. Is that correct?
Yes, it is.
Would that mean that those who were running the SMBTS on the CSA would also have been aware of litigation coming in against the SMBTS?
Oh, certainly so. I don't know that they would necessarily have become aware of it because they were in the same organisational structure of the Central Legal Office. I'm sure that if litigation was raised against a health board, the Central Legal Office would be in rapid contact with the health board.
Would that then be passed on to you?
To me?
Yes.
Why?
You wouldn't expect to have news of litigation brought against the SMBTS or the health boards brought to your attention?
Certainly not health boards. The SNBTS, yes, probably in the sense that I was that I was in the department responsible for the topic, but not as a matter of urgency. It would depend on the nature of the legal case. But what, I'm not quite. Yeah, I'm not quite sure what. Yes, on you go.
Let's turn to Professor Cash and his resignation as consultant advisor. Was the result of that not a lessening of his ability to give you advice, because you've said he continued to do so, but a lessening of the chance that that advice would be accepted by the SHHD?
Absolutely not. Well, I say absolutely not, but I don't have a before and after comparison. John Cash, while he was consultant advisor and afterwards. I just have the after picture. But in the after picture, we were so keen to get John's advice, not that he was backward in coming forward with it, that it would surprise me if we were any more enthusiastic while he was formally consultant advisor.
Thinking about your own reaction to his advice, would the formal mark of being consultant advisor have made any difference to your view?
Absolutely not.
The Scottish Government prepared a report that was published in October 2000 on an investigation into development of heat-treated factor concentrates at the PFC for the years 1985 to 1987. Were you consulted about that, or did you give any advice or any evidence as part of that report?
I worked at the time for the Forestry Commission, and the link was not self-evident.
I suppose the reason they would have consulted you was about your previous role rather than your current role. You don't recall being asked to provide these?
I would have certainly recalled, because it would have been such an unusual event, and it certainly did not happen.
Moving on to surrogate testing. This is to do with the relationship between the SHHD and the Department of Health, and the research that then took place on a UK-wide level. Firstly, the opinion of the directors in Scotland, as expressed in the letter to the Lancet and indeed elsewhere, was there's no time for this research now. We need to get cracking on. It's too late. Was that not in itself an evidence base for pressing ahead with surrogate testing? You have a body of considerable expertise with people with international reputation, such as Dr. Cash and Dr. Mcfarland, giving you that advice. Was that not in itself an evidence base on which to take that decision, or at least to put it to ministers?
Of course, it was part of the evidence that we took in coming to the constant revisiting of the decision. But there were other. Sorry, could you repeat the question, please, Mr. Hill?
When you have a body of expertise such as that presented by the SMBTS directors saying that we should press ahead.
Yes.
The time
I'm sorry, I recall now. I think the SNBTS directors were probably right that it was too late to carry out research, that research would have been worthwhile if it had been launched at the time that Brian McClelland had wanted it to be. I don't know that I knew that at the time. As the email that you threw up on the screen earlier indicated, I was really quite keen on that research to fill a hole a major hole in the evidence base. I was wrong in my expectations about the speed with which that research could be carried out, but I was keen for it to be carried out. But I think that's a slightly different question from the senior folk, the chiefs in the SNBTS recommending in the slightly backhanded way that they did in the Lancet letter, or in more direct communications at other times, that surrogate testing should be introduced. On that, I think we've very thoroughly explored why we, the department, came to the constant view that we did.
You mentioned a moment ago that you were wrong about the timescale that you anticipated research would take.
Yes.
Do you do the best you can now to think back to your views at the time? How long were you anticipating it would take for a worthwhile research to be produced?
Yeah, I have no recollection, but it seems from that minute that my hopes for an expeditious outcome were unrealistic.
The question, two questions following on from that was there a risk that the SHHD were setting too high a standard for the data that it required in order to introduce testing in a similar way to the Department of Health referring to no conclusive proof about HIV or about blood products causing AIDS? Was a similar thing being deliberately or otherwise undertaken here, but a high hurdle was being placed so that it would not be cleared?
That was not the conclusion of Lord Penrose's inquiry, which I read out earlier. I have no more authoritative view on the matter.
From your perspective, you weren't raising hurdles, you were interested in answers.
Could you say that again, please?
From your perspective, were you raising hurdles or were you interested in the answers the research would provide?
The latter.
And finally, on this point, to what extent was this desire for research, the SHHD falling in behind the Department of Health and following the rest of the UK, and to what extent was it an independent desire for this research to be conducted?
I'm afraid I can't remember, and nor can I recollect any of the mountain of documentation that bears on that.
The question of the Consumer Protection Act and consumer protection legislation more generally, do you recall taking legal advice from the law officers about possible ramifications of surrogate testing and not introducing surrogate testing and the Consumer Protection Act?
No, I don't recollect. We would certainly not have gone to the law officers, i.e. the government ministers responsible for advising ministers on their legal obligations. It's inconceivable that the legal questions would have been difficult enough that they couldn't have been resolved at official level from the department's lawyers. I don't recall whether I went to the department's lawyers or not on the question of surrogate testing. On the question of the Consumer Liability Act, I certainly would have gone to the department's lawyers on the implications. Indeed, one of the mountain of documents that you've presented me with is a circular that I issued not in my blood transfusion service responsibilities, but in view of my responsibilities for NHS procurement, a circular to health authorities, to health boards, about the implications of the Consumer Protection Act, and I will certainly have consulted lawyers about the wording of that advice.
What other resources or information or research impacted on your decision-making in surrogate testing other than the Dowell study?
I think we've, before the break, considered extensively the factors that influenced us on surrogate testing. And the point that I would emphasise in relation to that narrow question is that Dr. Dow's study was only one factor in a number of factors that influenced us in our view. And as I said earlier, I cannot imagine that it carried much weight with the Department of Health, which independently arrived at the same view. Dr. Dow was part of the Scottish Blood Transfusion Service. It had been funded by the Scottish Chief Scientist Office. It's a little unlikely that it carried weight in London.
Can you recall now any other studies or pieces of research that you relied on at that time?
No, I can't recall at this point. But I think that would probably, light would have been cast on that question, I think, by the Penrose inquiry.
We can look at the documents and the underlying documents.
Yes, I mean, you were throwing up on the screen earlier Lord Penrose's comments on the sort of academic basis of Dr. Dow's thesis, and I suspect that in that area of Lord Penrose's report, there must have been something about the other information of a similar kind. So it may be that to turn to that would assist you, but I cannot.
There's certainly reference to textbooks that were consulted by Dr. Reed, and we have Lord Penrose was able to identify which textbooks those were and which editions.
Okay.
That is there for people to be able to look at. A counterfactual question. Had you been aware of the limitations of Dr. Dow's study identified by Lord Penrose, do you think that would have led you to take a different approach on surrogate testing?
I'm sorry, that's too hypothetical a question for me to answer with authority.
Did you seek a view from Dr. Gunson about the likely prevalence rates of hepatitis C in Scotland?
Now, Dr. Gunson, as far as I remember, was the director of the Blood Products Laboratory at Elstree, is that right?
He was the consultant advisor to the Department of Health on blood transfusion. Elstree was Dr. Lane.
Okay.
Dr. Gunson was formerly the head of a regional transfusion centre and consultant advisor. Okay,
right. He's a name that I remember, but I had no contact with him whatsoever, and I certainly wouldn't have contacted him on this subject. It may be that my medical colleagues did so, but I have no evidence of that.
And did you seek a formal, informal piece of advice from Professor Cash on the likely prevalence rates of non-A, non-B hepatitis in the donor?
We will certainly have done so, whether I did so personally or not, and I imagine that there's information about that in Lord Penrose's report.
You think that's something that somebody within the SHHD would have done?
Oh yes, yes. Oh, absolutely. Yes, that would be an important bit of information. Unfortunately, I suspect that the answer would have been, we don't have enough evidence to bring to bear on the matter. Hence, the research proposal that was talked about.
Is it possible then that an answer of that nature, which is, I'm sorry, I can't help you, we don't have enough information at present, may have been conveyed orally rather than written down?
Yes, it's possible. John Cash was very good at providing advice orally.
Of course, that leaves us with the problem of not being able to identify it at this stage.
Yes, yes, yes.
That was done. Finally, on the Mcfarland Trust, if there had been involvement from the Scottish Home and Health Department and the Scottish Office in setting up and overseeing the Mcfarland Trust, would that matter have come to your personal attention, do you think?
I'm afraid I don't remember anything at all about the Mcfarland Trust, to the extent that I wonder whether the question you've just asked relates to the period for which I was responsible.
The Mcfarland Trust was certainly set up in the period during which you were responsible.
Doesn't ring any bells. It may be that it was the responsibility of the division in SHHD Group 5, which dealt with the problem of HIV infection.
I think that possibly answers the final question that I've been asked to put to you, which is how far we can go in deducing from the fact that you have no recollection about the formation and oversight of the Mcfarland Trust, how much we can deduce from that of the lack of papers with your name, a conclusion that the Scottish Office more widely was not involved in.
Yes, I think it would be dangerous to draw the conclusion that the Scottish Office more widely was not involved. It would have been the responsibility of a different division.
Mr. Macniven, those are the questions that I have for you. At this time, if I'm present in court, I would turn to your legal team and ask if they have any questions. And as I'm unable to do that, I will...
I think they're indicating that they have no questions. Is that correct? Yes, okay.
You're allowed to speak.
Say again?
Yes. Thank you.
Okay, right.
I have no questions of my own.
Mr. Macniven, as with all of our witnesses, there is now an opportunity for you to make any final comments that you wish to make.
I have none other than this, that the inquiry should not have the impression that the Scottish Home and Health Department, both administrators like me and medics like Archie McIntyre, was uncaring about the problem of non-A, non-B hepatitis, or indeed the problem of HIV infection, nor were we in the business of setting up bureaucratic hurdles to prevent the development of the safest possible blood products. Quite the reverse. We were very concerned indeed with the safety of blood and blood products, and partly, it has to be said, under the spur of the energetic and authoritative Dr. Cash, we were active in the matter. We were not setting up bureaucratic hurdles.
Well, for my part, could I thank you? It's obvious you're going to make your train tomorrow morning.
Assuming they run them.
Well, I was going to say thank you very much for coming down in what must have been a tentative journey at times, I suspect, to give your evidence here in person. It's very much appreciated that you've chosen to, or you've been able to do it that way. And I'm sorry that the arrangements had to be such that Mr. Hill wasn't here in person, although I think we have lost very little in the translation to the screen. But thank you again, in particular for the careful precision with which you've given your answers. And I note and take note of the slight hint of irritation at the suggestion that you might have been not quite as careful as you would have wanted to be. at the end, but you will appreciate that we have to, and entirely properly, explore all the facts in a way which inevitably, for many witnesses, will feel that we are taking, or the counsel, I should say, not me, I just listen to the evidence, is asking questions which you don't find, or the witness doesn't find entirely comfortable. But that's as it is.
I'm very grateful for what you say, sir, and I agree that Mr. Hill's absence in body but presence in spirit worked perfectly well.
Well, thank you very much for that. Now, Mr. Hill, are you ready to tell us what's happening tomorrow?
Lord Forsyth tomorrow, sir.
10 o'clock at Lord Forsyth.